welcome back to our regular Thursday Zoom sessions. I'm John Miller, founding attorney of Rock Solid Law, now in Ponte Vedra Beach. Come check out our new offices. We're not quite moved in. There will be art on that wall at some point in the not too distant, I hope, future. See a number of friends and some folks I don't know yet on the call today. Obviously, I made a very good decision to bring in fellow Rock Solid attorney, Catherine Espinoza. Kathy is senior associate here at the firm because more people signed up this week than I'd say the last 3 or 4 when I was doing it alone. So welcome, Kathy.
Thank you, John. And good morning, everyone.
So glad you're here with us today.
I'm happy to be here.
So you guys know that have been on with us periodically, and I do see some people who have been on other calls or other, whatever we call these things, videos, that in the estate planning arena, I really call myself an anti-probate device. There's some good reasons to avoid probate, expense, delay, and candidly, families fight often in probate. So I like to avoid that for the clients that I get to do estate planning with. But 80% of Americans die without any will. And then, of course, a good percentage of that 20% who do advanced planning have only a will and not a trust. And so those folks are all going in through the probate process as well. So one of the real reasons that I sought Kathy to join our firm earlier this year was because of her expertise in the probate arena. She is very, very knowledgeable of the probate practice, of ways that our clients can benefit if they are, in my opinion, stuck going through the process. There are also some very good reasons, depending on fact scenarios, to go through probate. And before I turn it over to Kathy, I'll give one instance because I just consulted with some clients recently. Unfortunately, there is an advanced stage disease. And so one of the members of the married couple is probably not going to be with us very much longer. As it turns out, in that family, the spouse who is dying has individual debt that is not joint debt with the other spouse, right? They have done a pretty good job of keeping their assets separate, and he has very little titled in his name at this point in time. So in their case, rather than considering a trust, we are going to take the family through a probate because during that process, Kathy will enlighten us on this a little more, through that process, we're going to be able to eliminate his creditors from the life of his wife and children. Okay, so there are sometimes good reasons for probate, and that's why we're here today to learn a little bit more, say in the next 15, 20 minutes from Kathy. And she's done some fascinating research that she shared a little bit with me. Don't worry, it's not boring research, it's fun research in the Rock Solid way. So Rock Solid Law, estate planning, probate, real estate, and small business representation. Today, we're going to talk about that probate piece. Kathy, will you take it away?
I sure will, John.
Thank you.
And thank you, everybody, for jumping on this Zoom video. And if you saw the little promo video that we did for this webinar, I was asked to come up with some fun facts about probate. And I said my mind went blank because, quite frankly, I couldn't think of any fun facts. But I found my book. We just moved recently and came across Wills of the Rich and Famous. So I found a few fun facts in here that I'll share with you a little later. But I went ahead and I did a little bit of research. I was just curious because Google, now we can find everything when we Google. And I asked Google, what is probate? And this was the response that I got. Probate is a court-supervised process for identifying and gathering the assets of a deceased person, paying the decedent's debts, creditors, and distributing the decedent's assets to his or her beneficiaries according to the person's will. But if they don't have a will, then it's going to go according to state intestacy laws. So what are state intestacy laws? If you don't have a will, the Florida statutes, they delineate exactly how the assets are to be distributed. They also state who's the PR, who they would give preferential treatment to for being the PR. And what is a PR? It's a personal representative. In some states, it's called they're called executors, but here in Florida, we call them personal representatives. So the courts, and if you don't have a will, they need to appoint a personal representative who is going to take care of all matters concerning your estate. First of all, marshaling assets. They need to find out what assets you have. If there isn't a will, sometimes people spend a lot of time digging through all your personal documents, trying to figure out exactly what you have. In order for them to do that, the courts need to issue letters of administration. The letters of administration is what allows the personal representative to have the authority to go ahead and discover and marshal all of those assets. If there isn't a will, who are they going to appoint as the personal representative? Well, the preference is if you're married, you have a spouse, the spouse is given priority. If there isn't a spouse, then your lineal descendants, who are your lineal descendants, would be your children. If there are no lineal descendants, then they look to your parents. If your parents are not available, then they look to your siblings, and it goes down the line. I recently had a probate situation where there wasn't a will. The gentleman was divorced, had no children, lived alone in his home, passed away in his home, was discovered a few days later by his cleaning lady. And we had to figure out who are the heirs in this situation. So a niece came forward, and then we found out that there were some others. She thought she would be the only one to inherit. Well, no, because we have to find out, we have to cover all bases. Who are the other heirs involved? We had to go and locate nieces and nephews, and they came out of the woodwork. So that was a tough situation for everybody involved because of the costs. So going back, I digress, to the letters of administration. Once the court issues that, then the personal representative is authorized to go ahead and start marshaling assets. Also, the personal representative has to, as John said, in the situation he described, that this gentleman had creditors. So we need to find out who are those creditors. And in doing so, the first thing we do is we file a petition for administration with the court. The court then issues the letters of administration. Personal representative goes ahead and gathers whatever information they can find, because there is no will, so you have to dig through all the documentation of the person. And then we go ahead and we notice creditors. And the notice to creditors takes 90 days. It has to be published in a legal periodical. And the 90 days start from the first date of publication. After the 90 days, during that period of time, creditors can file claims, because they all have to, the ones that we know of, have to be notified. The ones we don't know of, that's where the publication comes into play. After the 90 days, if nobody files a claim, we can begin to wind down the estate, meaning we see what assets have been marshaled. Also, there has to be an inventory filed with the court within the 60 days or 60 days after the letters of administration are issued. Then the inventory has to be filed. So the personal representative has about 60 days to go ahead and find out what assets are in that person's estate. After the 90-day creditor period, you can begin to wind down the estate. The inventory is filed with the court, so the court knows what this person has. By the way, everything is made public. The inventory is confidential, but it can be requested. So that's another reason that maybe you want to go the route of a trust instead of a will. But having said that, if you do have a will, there's a way that you can avoid probate. You can have beneficiaries titled on your accounts. And John always has a rule of thumb. If you have assets that are 300,000 or below, then you might want to consider going the route of a will. But if the assets are 300,000 or above, then you want to go and consider a trust. And maybe John can fill in on why a trust. But going back to the administration of the estate, so when you begin after the 90-day period to wind down, then you have to see who are the heirs at law if there wasn't a will. How are those assets going to be distributed? And usually if there is no will, then it's equally among the heirs at law. If there's real estate involved, then that also has to be reported to the court. And if it is your homestead property here in Florida, homestead property is your primary residence where you reside. And it is protected both from creditors and it is exempt in terms of having to go through probate. Goes through probate only because you need an order stating that that is your homestead property, and that order acts as a deed so that your homestead property inures to the benefit of your descendants. So that homestead petition is filed during the course of the probate administration, but after the 90-day creditor period. The court wants to know that all creditors have been taken care of, and the Florida statute classifies creditors as to who is paid first. First ones to get paid are all expenses that have to deal with the estate administration, court fees, if you have appraisers that come into play for the property, those are the people that get paid first. Of course, the attorneys get paid first, and also whoever acts as the personal representative is entitled by statute to receive a commission for their work. And there's a percentage involved with that. Attorneys are also, the statute provides for attorneys' fees. They can get 3%, depending on what the assets of the estate are, up to 3%, or I think maybe even more, because there's hourly fees.
If they provide extraordinary services, right?
Yes. And so there are a lot of costs involved with going through probate, but as John said, in some instances, it may be the way to go. For example, the instance he gave of the gentleman who had creditors.
But guys, sorry, Kathy, even the Google definition of probate was painful to listen to, right?
Yes.
My point, as always, absent a really good reason, like the one we discussed, it's not a great idea to put your most loved family, your most loved friends through that process after you're gone. It's hard to even listen to the definition and then think about living through everything that Kathy just described, right?
Yes.
So that's why not everybody who has $300,000 in assets needs a trust, but that's where we need to consider it and consider what planning for the future of their family means to that individual, right? Folks with less than that amount of assets, we can make some good plans that provide that prohibit the worst of probate from happening, but we can't speed it up. I mean, courts are slow, and somebody has to do it, and they're absolutely going to have to at least hire a lawyer, right? And maybe an accountant,
Yes.
and maybe an appraiser, evaluator of some kind. So there's all sorts of other professional fees and other fees which can be a part of the probate process. Not to even mention fake creditors who come out of the woodwork.
That's right.
And file a claim just hoping they'll get paid. Obviously, they're successful often enough that it's worth their while to continue that practice.
Yes.
So.
And going back to that one example I gave about the nieces and nephews, that was a really tough one for me, because the one niece who was appointed as the personal representative decided to take over her uncle's home, although there were other nieces and nephews involved, some of which never met the uncle, and the uncle didn't even have a relationship with them. And he might have been turning over in his grave, knowing that these people benefited from his hard-earned money. Yes. Yeah. And so she wound up living in the house under the guise of, I'm going to maintain it and take care of it. And they wound up having to do a partition action, sort of like an eviction, to get her out of the home. And she really wasn't maintaining it in the manner that it should have been. The last I know, the attorney's fees were up to $27,000 in that one estate. So folks, the bottom line is you really don't want to go through probate if you don't have to. But it's there if you have to. And sometimes you just have to do it and bite the bullet if you don't plan. If you don't plan for what is inevitable, and that's what we were talking about earlier, death and taxes.
Oh, these are going to be the good quotes. But let me say, I don't know the situation that Kathy's talking about, but I wonder if the dead guy, the decedent, actually even knows the lawyer he or his estate paid $27,000 to, right? Could have avoided all that for definitely probably under $5,000. Right?
Correct.
So that's a $22,000 swing to a complete stranger.
Correct.
And there are law firms that their business plan is to get you to go through probate because it's very profitable, and they want to send their grandchildren to private colleges and graduate schools and probably law schools. But most of my clients, that the priority of the wealth of some lawyer they don't even know isn't first and foremost on the values that they're doing their estate planning. All right. Yes, we're perfect timing. Kathy, share some of these cool things you found.
So here's one of the things I found in my book, just little fun facts. So it says that a failure to make a will sometimes is a person's way of avoiding the fact that, you know what, we are going to die. It's inevitable. We're not made to live on this earth forever and a day. So a will is also designed to address those unavoidable circumstances, which Ben Franklin said guaranteed death and taxes. But it's often unnerving for a person to have to come in and sign their will because it addresses your death. In the case of perhaps the wealthiest artist who ever lived, Pablo Picasso, he died with an estate estimated to be worth anywhere between $300 million and $1 billion.
Wow.
His failure to have prepared and signed a will has been attributed to his superstition that signing his will would hasten his demise. So there you go, folks. It's inevitable. And we've learned this in the past year and a half. I don't know about you all out there, but time is precious and families are precious. And so if you really care about your family, you don't want to leave a mess behind. And with COVID, we've seen it's just, life is too short. So prepare.
I didn't know about Picasso's particular superstition, but I have a theory that people have some underlying stress when they don't do their estate planning, and that by completing it relieves you of stress. And we all know that stress is hard on our physical plant. And therefore, by alleviating stress and doing your estate plan, I think you're going to live longer. So I have to disagree with Picasso there. And by the way, back in the 70s when he died, $1 billion was real money.
That was a ton of money, right? And the other thing is that this is a little fun fact that I found interesting. So there are many, many wealthy, well-educated, and famous people who have died without valid wills. And it said the list of those is headed by President Abraham Lincoln. Lincoln's failure to have a will is unforgivable because he was also one of the leading lawyers of his day. So there you go. Even presidents, many presidents, died without wills.
I don't have the stat at my fingertips today, but actually the percentage of American lawyers who don't have estate planning is higher than the percentage of American non-lawyers. So You are already smarter than a lawyer, but tell your family and friends to be smarter than my fellow counselors at the bar and get your estate planning done. Hey, Kathy, before you go on to the next one, guys, we're kind of getting close to the end, and there is a chat bar that several of you have kindly wished us a good morning on. If there are any questions that we can field before we wrap up and after Kathy gives you the next one, which I love, please type them in the chat bar, and we'll hit those before we bid you adieu today.
So this is the last one I'll share with you, but I thought it was kind of cute. It says, comedian W.C. Fields, whose death was partly attributable to his excessive drinking, expressly gifted 1/3 of my liquor to each of 3 of his drinking buddies. So there you go. You can even bequeath liquor if you have a good, nice bottle, expensive liquor to one of your drinking buddies.
I guess I've got to update my plan. Oh, that's funny. I'm not seeing any questions. We couldn't have been that much of a model of clarity. There are, here comes one. Thank you, Scott. What document do you need from a judge to sell the home?
You need the order. I was speaking about homestead. So it's called a petition to determine homestead. And once you file that petition after that 90-day creditor period, the judge will issue an order determining homestead. And that order goes ahead, it acts as a deed, and it authorizes the beneficiaries of that homestead to go ahead and sell the property.
So the short answer then is order determining homestead. And there are, by the way, several videos at Rock Solid Law /videos about homestead. Those of you that are long-term Floridians probably know that we have one of the strongest homestead protections in 4 different ways in our state. We are really, really fortunate. I mean, there are lots of good reasons to be fortunate to live in Florida, but one of them is our homestead protection is huge, and it really helps us as planners of the future of your family. Looks like there's another one, Kathy.
You want to go ahead and do that one, John? Should all personal accounts, checking, savings, investments, be titled POD, which means paid on death?
There should be a death beneficiary, either a POD or a TOD for all accounts. Depending on each individual and what their family situation is, that can either be the names of beneficiaries, or it may be flowing into a trust where distributions are perhaps held to be given after people mature a bit later in their lives, or when other certain circumstances happen. So that's a fantastic question, Rob. Yes, the answer is yes, but the answer of what to put in there is not simple and is different given the circumstances literally of each person's life.
Yes.
So
and it will avoid probate, because anything that any accounts that have a specific beneficiary or POD, TOD on it goes directly to that person upon death. So it doesn't go through probate.
Exactly. So we're not shilling for wills of the rich and famous, but I can't wait to borrow Kathy's copy because I've heard of this book forever, and I know there's a lot of fun stuff in there. If you have some spare time on your hands, it may be the one law book you want to read this year.
It went through Hurricane Andrew. That's why it looks all beat up. But
yeah. Oh, we got another question. You guys are great this morning. You've got your glasses on. I don't.
Did I hear you say that you don't have to go through probate if your assets are joint and the home is titled with a family member? Do you still have to file the death certificate with the court, or does the funeral director do that? So when a person passes, if they have a will, the will has to be deposited with the court. And you go to an attorney, or you could go to the clerk yourself and deposit it. But if it has to go through probate, then an attorney needs to be involved with it. But if your assets are joint and you pass, then whoever is on that joint account is the owner of the account
By operation of
by
law.
operation of law. As far as the house goes, is if it's joint, you're married, it's tenants by the entireties. So all that needs to be filed is a death certificate and an affidavit of continuous marriage. And those are filed with the property appraiser, correct?
I think that's correct.
Yes. And so that would not have to go through probate. But if both people who are on that deed are deceased, that has to go through probate.
Right. So there are ways around that. There are ways to plan around that. There are ways to deed and title around that. You guys are asking fantastic questions today. And I will tell you that we try to take a holistic approach to estate planning. And part of what we're going to do is make sure we answer all those title questions for real property, personal property, accounts, all those things in the process. And we actually go the next step further that I am aware many firms don't. And I began doing this because I found that a lot of people, though well-intentioned, don't go out and do the retitling on their own. So our firm assists you in getting things titled properly. I just, Betty, that's a fantastic question. I honestly don't know of funeral directors filing the death certificate. I have not heard of that. There may be a funeral home in town that provides that service, but that's not something that I'm familiar with. But then again, I don't own a funeral home.
I haven't heard of that either. I know that they notify Social Security of the death of the person, but that's all I believe they do. So my recommendation, just to wrap up here, is don't put it off. Come and see us, or whoever you feel comfortable with that is going to care about you and your family and what your goals are, and plan for the future. We plan for everything in life, for weddings, for baptisms, but this is inevitable. Take care of it. Don't leave a mess for your kids to have to take care of, or your loved ones to have to clean up. It's I tell my parents that all the time. My mother would say, yeah, she's telling me to go ahead and get rid of stuff. You don't want to have to do that. You're grieving. You don't want to have to clean up a mess.
Absolutely. Hey, you guys, in gratitude for your spending, looks like a full half an hour with us this morning. If any of you would like to sit and just have a conversation about where your or your loved one's status is and see if there's work we can do together, we will waive the fee to come talk to Kathy or me about that, or you might be very, very lucky and get us both. I don't know whether you consider that lucky or not. Anyway, give a call at the firm. That's 904-241-1113, or you can just go on to rocksolidlaw.com, or you can email questions@rocksolidlaw.com. And our amazing team, all women, fantastic human being team, will get you set up with Kathy or me at our convenience. By the way, if there's a question that is just one you didn't want to share on the Zoominar, shoot that to questions@rocksolidlaw.com too, and we'll be glad to get you back a response. If there is a quick response, if there's not one, we'll ask you to spend a little time with us. Hey guys, have a fantastic week. I'm taking my kids to the Grand Canyon, so we're skipping next week. We'll see you in a couple weeks. Kathy will be here taking care of business. Here's the Commodores. Bye-bye.
Take care. Bye.